Hey everyone, Harry here to talk about Justice Juan Merchan's charge, the legal instructions that he provided to the jury this morning. I was there. The charge is a very sort of sober affair. He's looking straight at the jury. It's, I think, everywhere. You can't go in the courtroom when a jury is being charged. You can't leave the courtroom when a jury is being charged. And it's this, sort of teaching event on the one hand, and on the other, because false or erroneous charges can so easily give rise to appellate reversal. There's a lot of charges out there, especially the general ones, that a judge gives in every case, but they're a little perplexing, a little bit of legalese, and the jury just has to sort of hang in there. Okay. The charge today took about an hour, and half an hour or so were just these bromides that anyone who's been on a jury would know about. But what's an inference, and what's circumstantial evidence, and what is intent as a general notion, and what do you have to do when you deliberate? So you could really plug them in or out in a lot of cases. And then about half were the nitty-gritty of this case, the so-called, the 34 counts, and he went over one very carefully and then sort of blitzed through the other 33. Now, the jury, I want to report, was very focused and attentive on him. All 12 were, well, really it's 18. The alternates hung in there. They still haven't been dismissed, but we're really looking, very strongly at him, really concentrating. Sometimes when the legal language got a little tough sledding, they would, look to their screens where there was the language and then look up at him. But it was, again, a very attentive jury. And every single one of them was that way. I think I've mentioned and caused a few ripples. What the hell? A juror who I and others are wondering about, will she or he be a potential holdout? I can just report that all 12, including that juror, were definitely locked in on Judge Merchan. The big thing to emphasize is we're now over the point of arguing about the legal theory, which, as I've suggested, is a little bit complicated and subject potentially to confusion or reversal. But reversal, I don't think, is likely. I mean, Merchan went with the sort of thrust of the law in a couple places that it was, a little up in the air. And it would be 18 months from now, 2 years from now. That's eons away in America Trump time, when it'll either be President Trump or defendant Trump all the way around. But the potential for confusion, I think, was at a minimum. And it's, now to them in a pretty understandable theory. And this is the theory. So the charge is 175.10, and that's falsifying business records with the intent to further another crime. If it were just the misdemeanor, it would, without that extra intent, it would be 175.05. But significantly, nobody has raised that. It would have been in Trump's interest to have the jury charged and consider that. But the people who know him best say that, a guilty verdict on the misdemeanors, which you might think he could play as a victory, he would be anathema to him as well. So that's out the window. So we have, you've falsified papers, and you've done it with an intent to commit another crime. And the next step is also basically clear. It could get a little tricky on appeal, but it doesn't matter anymore on appeal. The question is it pretty understandable for the jury? I think it is, because they're saying a single law that they have the intent to violate, and that law under the New York Code makes it a crime to try to promote or undermine a candidacy of a candidate for public office by unlawful means. That's the statement of the actual law. So here's what we've got. So far, so good. Pretty basic. You committed this, what would otherwise be a misdemeanor, by falsifying papers. How do we know that? Well, you caused, because that's good enough. Trump didn't have to do it himself. Falsified papers to be created. And, I've talked to you already before of why I thought it was so inane for the defense to try to fight on whether the papers were false, because according to this defense theory, Michael Cohen really was performing legal services. I don't think that will give the jury 5 minutes of pause, and working it so definitively against them. I think it puts the defense in a hole from which they start. But anyway, he caused false papers to be created, and he did it with the intent to promote, to further another crime. And that crime is the New York crime that says you cannot basically promote or undermine a candidacy of someone for public office by unlawful means. So, that is pretty much straightforward, and it's that second point that makes it a felony. And just one thing to be clear, that intent, the unlawful means part, you must have that intent beyond a reasonable doubt, but you don't have to complete the crime. You just have to, you have to have beyond a reasonable doubt to be convicted of felony and intent to further this other crime. And this other crime is basically trying to get someone elected or not elected by unlawful means. Okay, here's where the sledding gets slightly tough, but I think minimally given the way it was resolved. So the DA is saying, and the judge has charged the jury, here's a choice of here's a menu, 3 unlawful means. And said the judge, this was controversial. They fought about it at the charge conference, but the DA won. And this is the way the law seems to go. And again, if it creates an issue on appeal, see ya in 2027, where who knows what dystopia we are living through, or what dystopia we have been able to elude. But anyway, so the unlawful means, I'll give you a choice of 3, says the DA. Here's the first, and the one they are really, I think, stressing, the one they hope the jury will just embrace. It's against the law. It's a crime. And in fact, Michael Cohen pleaded guilty to this crime. And in fact, the National Enquirer entered into a non-prosecution agreement over this crime to give a contribution in excess of federal campaign limits. And there are different criminal charges where people try to get around them or give them to other people. But if they're exceeding the $2,700, that was the figure at the time, that's a crime. And as I say, Cohen pleaded guilty for these very facts. And that means that he admitted, and the court accepted the notion that the payback of Stormy, is it 120, 130? Are we thinking it doesn't matter because we're way, way above the 2,700, was a contribution to the campaign. And Judge Merchan read instructions that made that clear. Basically, it's a contribution to the campaign, except in very rare circumstances, as long as, that's one of as long as, and now we get to the sort of Melania question, you would have done this anyway, even if you had another reason. And with the overwhelming evidence about the existential crisis with the Access Hollywood, and everyone's wanting to salvage the candidacy, it seems pretty strong that that was why it was done. That means it was a campaign contribution. That means it was more than 2,700. That means it was unlawful means. So follow with me. It's not as complicated as it could have been. You did false records. You did it to further the crime of trying to promote someone through unlawful means. And what's the unlawful means? The main one they're going at is the breaking of federal law about how big a contribution you can make. Now, there's side litigation. Can you use a federal law for this? And the majority of the very sparse law out there says you can. Again, we don't really care. It would have been one thing if they could have argued it to the jury, but now if he's convicted on this theory and 2 years from now, it turns out to have been infirm, we'll deal with it then. All right. But there are also 2 other unlawful means offered to them. And by the way, not only do they not have to agree on them, it doesn't have to be beyond a reasonable doubt, because under the law and their Supreme Court of the United States precedent on this isn't an element of the crime. It's what's actually called a means of a crime. So, a deadly weapon, maybe it's a knife, maybe it's a gun, maybe it's an anvil, but it's not an element of the crime. It's a means by which you commit the crime. So they have offered a couple other theories. One is a tax violation. And importantly here, Merchan charged the jury, you can have a tax violation that doesn't produce a loss to the public fisc. So if you lie about things, and it can be a tax violation, and here that's what they did, even though the upshot was to treat something as income and therefore give money, like, what was it, about $170,000 in taxes that Michael Cohen paid on this income, which really wasn't income, it was reimbursement. And then there's also a theory having to do with state election law and the submission of false records there. Does that count as unlawful means? That's clearly the kind of third theory. So the 2 that are really presented to the jury for the jury's reflection are this federal election act and the contribution limits, and then potentially the tax violation. The third is creation of basically another 175.05, the creation of false records. And here you would be looking at, say, the 1099, which is given to Michael Cohen and has this money falsely characterized, even though that's not one of the documents that are charged in the 34 counts. So there you have it. With that, the jury also was permitted to take a laptop with all the evidence back with it in the deliberation room. Everyone is now on tenterhooks, waiting for, perhaps questions. They were not permitted to take the instructions back, but they can ask for them. I think that's probably a good thing, so the 2 lawyers don't, tie things up too much in legalese. They can have anything read back to them. They can ask the judge questions. And in a typical trial, there would be a couple questions before verdict, and everyone will engage in some quick tea leaf reading about what it augurs for where the jury is headed. But that's the deal. Case is submitted. It's all she wrote, and it's now with the 12 men and women of the jury in New York versus Trump. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.